Good morning, ladies and gentlemen.
We are just not with the sub.
Right, we're voting.
Welcome to the Economic Development and Tourism Committee meeting.
Okay.
Okay. Yes, we're ready.
Let's open in a quick word of prayer. If you bow with me, please. Father, we just ask your blessings on today. We ask you to help us be mindful of our words, our actions, and our deeds. Bless our steps and how we treat one another. These things we pray in your name. Amen. So this morning we have one bill, House Bill 244. Do I read the caption on that? I believe, Mr. Chairman, you'd like to speak to 244?
Thank you, Mr. Chairman. First of all, let me apologize to the committee for this early rise. And yeah, I know, I'm sorry. I hear a mutiny on the horizon. It was that or 3:30 in the afternoon, and I figured, so now that we're here, I'm here to, I'm sorry? Or Monday, yeah. But now that we're here, as you might know, but most of the things that have to do with broadband are coming through this committee. We've been working on that through the Rural Development Council now for 2 years. Representative Parsons, Chairman Parsons, even did this, tried to get something rolling 3 years ago, so this is not something that's brand new. But we've already given the authority, which passed through this committee and passed out of the House, the authority for the EMCs to get, which already has infrastructure there, in the rural areas to get into the business of broadband. That is a huge first step, but also the first bill allows them to get federal dollars to expand out into the broadband in the rural areas. And of course, the small cell is the other bill that we passed the other day. That one, of course, is there thanks to this committee and its wisdom, and without any objections, that bill is moved on as well. But we have the potential for a monopoly and a potential to keep competition out in these rural areas if we can't come to a pole attachment agreement. That's what this bill does. It goes strictly to the straight to the issue of the federal regulations, the federal pole attachment fees, which is essentially all this bill does. So, Mr. Chairman, with that, that's the meat of the bill. It only it allows for competition within these areas through a generally accepted, a Congress-approved federal fee, which has to do with the entire pole, not just the usable section of the pole, but the cost of the entire pole, even the amount that's under the ground. So this federal rate is there, and Mr. Chairman, that's the crux of the bill. I certainly hope the committee will see fit. We've got some speakers on both sides today that will move this bill forward, and I'll take any questions the committee may have.
Thank you, Mr. Chairman. Are there members that have questions? All right, without any questions, we'll hear from our first speaker, Stephen Lofton, Georgia Cable Association.
Thank you, Mr. Chairman, and thank you, Chairman Stevens, for sponsoring this bill. It's a very important piece of legislation. I have with me today Andy Mackey with Comcast. He's the Vice President of External Affairs and has a wide range of knowledge of this issue as well, and he's here to answer any questions, which I won't be able to answer, which will be most of them that you may have. But there's really, I think, two arguments in support of the bill. And the first one is that fair is fair. Fair is fair. And what I mean by that is there's a disagreement between the EMCs and us as to how to properly price the pole. We don't want to be on the pole for free. We should pay the proper cost for the space that we use on the pole. And what the disagreement really gets to is the unusable space, as the chairman mentioned. So in your packet, you should have this document. There's one side that is for the policy wonks, for those of you that like to read a lot of big words, and then on the other side is the picture for people like me, which is a much easier way to explain this. And what we're doing is we're leasing space on the pole. And we lease a foot, we're allocated a foot on the pole. The EMC is allocated 8.5 feet on the pole. And just to keep it simple, that there are typically other attachers on the pole, but we'll just leave it at 2 for today to make the math easy to understand. You can compare that to an office lease, right? In an office building, and let's say this is the EMC's building. They have 9 floors, we have 1. There's no question about what rate is appropriate. We should pay 9/10 of that. They should pay 9/10 of the usable space. We should pay 1/10 of the usable space. The question is, what do you do with the unusable space? What do you do with the lobby, the bathrooms, the hallways, the grounds, the maintenance, all of those things? Should that be split down the middle, 50-50? Well, no, that doesn't make any sense. We're only 1 floor out of the 10 floors. They should pay 90% of the cost of that unusable space, and we should pay 10%. That's how every lease in buildings work. This is the same way. The amount that you pay for that unusable space should be equal to your use of the pole. And that's really what this comes down to. Right now, we pay about, and that is what Georgia Power does. They do that because of the FCC rate, and Congress passed a bill that would require a formula similar to this. The FCC set the formula. It was litigated all the way up to the U.S. Supreme Court, and the U.S. Supreme Court found that the formula that the FCC used fully compensated Georgia Power for our use of the pole. It was full, just, reasonable compensation for our use of the pole. The other argument for this bill is rural broadband. When you pay 3 times the rate, and we pay about $20 to the EMCs, whereas we pay Georgia Power about $6.50. When you pay 3 times that rate, that is a barrier. That does come into play when our companies are making decisions about where they can serve. And in the 3 to now almost 4 years that we've been traveling around the state, learning about the rural broadband issue, trying to figure out solutions, Ms. Holmes has been a proponent of it and has been actively working on it, and many of the members of this committee have, and you're all concerned about it, and rightly so. And I think the phrase that has been used the most in all of those discussions is, there is no silver bullet. And that's the truth. There is no silver bullet. Fixing this will not fix rural broadband. Just like providing the EMC's authority will not fix rural broadband. It'll help. It'll give them the ability to draw down that federal money, so let's do it. Why not, right? But if you're confronting a large problem, if you're confronting a monster and you don't have a silver bullet, then shoot every bullet you've got, right? Use them all up. Empty the clip. Pass everything you can pass to address that situation. And that's one of the things this bill does, is it helps get us into those rural areas. Mr. Chairman, thank you so much for your time, and be glad to answer any questions.
Thank you, Mr. Lofton. Are there questions from the members?
Can you hit your button? What number are you?
What's her number? There we go. All right. Representative Valencia. Stovall, excuse me.
Pole comes down, and typically the pole owner comes and maybe does a temporary solution, but ultimately the pole owner replaces that pole, and then all the folks that are attached to that pole move their attachments over to the new pole. Now that cost associated with that is baked in to the federal rate, the FCC rate. Those costs associated with maintenance as well as depreciation, it is a fully loaded cost that is contemplated in that rate calculation that the FCC and 21 other states have also gone with in terms of poll rates. Sure. There is a system in place for situations generally where a new pole is put in, whether it's a road widening, whether it's an intersection improvement, or a rotten pole, or whatever it is. It's called engines, and it's a database that essentially there's a kind of an order in which you move your lines from the old pole to the new pole. It typically goes from the top down. So the power goes first, and then on down the way. And so so when you're the next one to go, you get a notification that says, "Okay, you go," and then or I'm done, and now it's your turn. And so there's a system in place. Now, if there's an emergency where there's lines laying in the road, then that's typically a situation where the engineers with an electric utility know their counterparts through utility coordination committee meetings or whatnot, and phone call, "Hey, you've got a line laying over here, get it rectified," and usually that works. Not 100% of the time, but that's generally the process.
And I'll just add one other thing, Representative Stovall, and those are great questions. Thank you for them. And they follow up on the questions that Representative Henson had in that last meeting. Yes, ma'am. So I did want to bring up that we are working in the Senate with the EMCs. We're hoping that we'll be able to put together a process, a dispute resolution process that would be handled by the Public Service Commission, where they would be able to go to the PSC and say, "We can't get any relief, whoever the attacher is," and it may be us, we're not perfect, we make mistakes too, that the PSC could then get involved and say, "Move it, get it done." And then we'd also have access to that system if there's disputes on our side, on a term, on permitting, something of that nature. And we're working cooperatively with the EMCs, and we appreciate them working with us.
All right. Real quick, remember that Chairman Powell intends to operate this room at 9 o'clock, everyone, and I don't intend to get on his bad side today, okay? One more, quickly.
What's the anticipated impact for workforce, being that you all will now be doing something, additional, and it's what's with training of potential workers in this industry?
So from a workforce standpoint, ultimately, what this bill provides for is a level of certainty. What is the rate? What are the terms? What are the conditions in terms of how are you going to deploy broadband in urban areas as well as rural areas? And that certainty creates an easier path to make capital investments. There have been, pardon me?
Speed to market.
Yeah, speed to market. There's a number of situations where we've deployed projects with hundreds of thousands of dollars in rural areas, and then all of a sudden the rules change. And right now there's no protection to allow those rules to change. But if you were to codify the rates, terms, and conditions, and the rates are the headline, but the terms and conditions are also important, then you create some certainty as to what the rules of engagement are. And it's long since been recognized that pole attachments are an essential facility. And there is no market for pole attachments. If I can't get on this pole right here, I can't go around the corner and attach to a pole that somebody else owns over there. My choice is to go underground, which is 5 or 10 times the cost, depending on what's the terrain.
Good answer.
All right, thank you. Yes, next, 60. Try the one next to you. No, I need you to use the mic so that if you could, hold on just a second. To the right. We need to make sure you get on recording. We've got a problem across the board then. Let's try that now. How about that? The one to the right? 15? Try it one more time. Nah, we're not working. Okay, state your question, please, best you can.
I miss some of these meetings, and I just want to know, just, we're dealing with here in my area, obviously, how many customers per pole or per subdivision, per half mile, how many customers do you have to come in and build the officer?
So for every company, that's different. We have 5 companies, and there are some companies that their number is one thing, and in other companies, for example, MediaCom, which serves in Southwest Georgia, or Vive Broadband, which serves in Waycross, that's a much smaller number. They've chosen to serve in rural areas, and they've got a little bit of a different model. Andy, I don't know if you can address that for Comcast.
Sure. And as Stephen said, there's wide variability. And the two equations are the same as they are for all businesses. A, what's the cost, right? What's the cost of serving this number of homes or businesses? And this bill directly impacts the cost in terms of the hard cost of what it costs to rent a utility pole or space on a utility pole. It also impacts the cost in terms of how long is it going to take me to get a permit to get on that utility pole. What are the rules of the road in terms of what are the imputed costs that I'm going to deal with over time to be on that utility pole? So this bill absolutely impacts the cost. And then the other equation is obviously the revenue. If I'm going to build a subdivision, and we're not in a monopoly business, so if I build past 10 homes, I have no guarantee that those 10 homes are going to subscribe to my service. I may get 1, I may get 2, I may get 10. And so ultimately, and then each of those 10 homes may subscribe to a different level of service. What if we were the only option? Well, even still, there's...
If you were running a mile, how many would you think you'd have to get down that mile to make it worth your while?
Is the mile aerial? Is the mile underground? So let me just kind of put it in rough numbers, okay? So typically, it's going to cost in a rural area, it's going to cost you somewhere in the neighborhood of $25,000 a mile, okay? That's kind of just a rough off-the-cuff number. And, you know, what we are looking for from a business standpoint, our typical investment profile, we're looking to recover our capital investment over and above the cost to provide the service in about 3 years, 36 months. Now, we're willing to go longer where there is where there is an opportunity to, expand to in a rural area and there's some social benefit there, or what have you. But that's generally the math that we're working off of.
Thank you. Representative Williams, I believe you're up. Would you try your mic? We might have this fixed.
Okay. You all understand that this mic will always be on if you need one. But I've lived all my life served by both of the power companies, EMC and Georgia Power. And now everybody that's involved in this discussion is going to be in my area. There's 2 things. First, to Representative Stovall's questions. All we do in here is so vitally important to make it work. But her question is the question our constituents have. It has nothing to do with the technicalities of this bill and the cost per mile, etc. Because my experience has been, without calling any names, that her question has a lot of validity. So I just went through 2 years of stuff that never got cleaned up.
Yes.
EMCs, as a rule, do an excellent job, along with Georgia Power and along with the cable companies, of coming in and trying to correct the problem. But it's vitally important that there be a process, because the answer is sometimes different for Aunt Hager and Representative Boo. So it's different. The question to the gentleman's question, when we get past all the dollar cost and all of the realities of business, the question that my constituencies have, if I get lights, will I get broadband. See, all other stuff is irrelevant. If I can turn my lights on, can I be covered by broadband? We understand the cost, but folk ain't never asked me what it costs a mile. They just want to know will my lights come on when I click them on, and now will my computer pick up Wi-Fi when I get ready to use it. Those are questions I got to answer back home. All the other ones, I know you can answer, and we can talk about it, but they don't mean nothing in Briar Bay and Riceboro.
Yes, sir. Thank you, Representative Williams. We agree. That's why we're so excited about the dispute resolution conversation that we're having with the EMCs, because we think it benefits both sides, and we think it gets us to a place where those issues will be resolved faster, which will benefit your constituents, those consumers. We also feel like this bill, in addition with the other bills, such as the ACE Act, are going to help both address cost as well as making up that gap, because you can address every cost that we have. You can lower them as low as you can, and there's still going to be places that are going to be hard to reach. And that's where the ACE Act comes in, and funding the ACE Act. There's some other ideas in the Senate as well that I think will be coming your way regarding tax credits and those sorts of things for individuals. There's a lot more that can be done. This is a part of the package that will help drive broadband just as far as we can drive it. But thank you.
All right, thank you. Representative Weeks, is yours on? 34? Did you request to speak? Yes, did you request? Use your, I need you to use your mic if you would, please. It should work. Did you have a question, sir? Okay. Try it now. Try the one to the right of you. How about that? All right. Hold on a second. What was your, there we go. Try that one.
Hello?
There we go.
Oh, I was looking dumbfounded because you called me Representative Weeks.
I'm sorry. My apologies. Okay, please proceed.
Thank you, Mr. Chairman. First of all, I want to thank you all for this industry, for the work that you did in my community and in my district in responding to Hurricane Michael. You all really came in and did some great work, particularly in Dougherty County, making sure that our constituents had utilities and that the broadband that was there, the cable service and the internet was restored rather quickly. One of my questions is this, though, and that is, has those kind of catastrophic events been cooked in the cake, as you say, when you start talking about cost per pole?
So in the current contracts that we have, I would say no, right? Because it's a rate that is set into stone. That's what we think is one of the benefits of moving to a formula, because as costs go up, the formula goes up. So if you have to replace a bunch of poles all at once, you're compensated for that because your formula is different, than the inputs are different the next year. So for example, in coastal areas, if the decision is made that they need to harden those poles, set them in concrete, or just use concrete poles, for example, then those costs would go up, the inputs would go up, and therefore the costs that we pay would go up. And that's appropriate because you then have a better pole to attach to, a stronger pole to attach to, which saves us money because when that storm comes, we don't have to come back out. There will be more poles that will survive those type storms. And in Florida, they've done quite a bit of that. So that's the other benefit of using a formula, is that as your inputs change, the rate changes, as it should. Thank you for your question.
Follow up. Does this piece of legislation address the concern that you had between the dialogue that we had in the last Economic Development Committee meeting?
Yes, sir, it does. Thank you.
Well, one of the things that we did want to do, and I'm glad, we don't want to put anybody legislate an unfair competitive advantage for anyone. That would be the last things that we want to do. We don't want to pick winners and losers.
Yes, sir.
What we really want to do is to make sure that there's an inherent fairness of all of the people who's going to compete in this industry.
Yes, sir.
And it appears as if we have risen to that hurdle.
Yes, sir.
So we look to see you all with bringing broadband to rural Georgia. Thank you.
Yes, sir. Yes, sir. As I mentioned, fair is fair. I think that's your point. Fair is fair. Thank you.
Thank you. Mr. Gamble?
Thank you, Mr. Chairman. My question kind of touches on what Chairman Rhodes and Representative Williams said. What kind of assurances or commitment can we get that if you get the FCC rate that we will be able to get in unserved areas?
So I would say that the industry is willing to come back and report to you what we did with the money. Okay. We think that's a fair question. If we get the rate that we're looking for, what have we done with it? And we're willing to do that. We're willing to come back and tell you where that money has been spent.
All right, thank you, gentlemen. We appreciate you entertaining the questions.
Thank you so much, Chairman.
Mr. Berner, Georgia EMC.
Thank you. Good morning, Mr. Chairman and members of the committee. My name is Bill Verner, Senior Vice President, Georgia EMC, and we appreciate the opportunity to speak to this bill. I have with me today David McCullough, who is here. He's manager of Joint Use Contract Services for TRC Engineers. He's been employed with in this sector with the same firm under different names perhaps for 21 years, specializing in joint use matters with a primary focus on operational procedures, working with working knowledge from assisting Georgia's EMCs with provisions of the model agreement we have for both AT&T and with cable television companies. Outside of Georgia, he also works with clients, electric cooperatives, municipal utilities, and other public utilities in Alabama, Mississippi, Louisiana, Texas, South Carolina, North Carolina, Florida, Arkansas, Tennessee, New Hampshire, Maryland, and Virginia. So David has a wealth of experience and is here to answer any questions that you might have of a technical nature. There are a number of things that our counterparts with the Cable Television Association, Mr. Lofton and Mr. Mackey, have said that we do agree with, and we all have common interest in serving our respective customers. We have different business models. The electric cooperatives are a nonprofit, cooperatively organized business owned by our members, governed by our members, and the biggest divide in where our business model departs from those in the telecommunications sector in general and specifically cable has to do with, we're an essential service provider of electricity to the state. As an essential service provider, the state has granted, in fact, a monopoly for the EMCs, just as they have for Georgia Power and just as they have for the electric cities. That monopoly was granted in 1973 as part of the Territorial Electric Service Act that was voted on by this General Assembly and probably had hearings in this very room. That Territorial Act of 1973 does provide assigned service territory for every single customer in this state. Where you have a mailing address, you have an assigned electric power supplier. The only choices for electric power supplier are if you are say the size of a Walmart or larger, connected load of 900 kW or greater, and you're outside of city limits as they existed in 1973 to take annexation out of the equation, then those providers have a choice. They can solicit bids from the power suppliers, and we compete. That's one of the great things about Georgia's economic development role, and this committee, I think, is well aware of how customer choice has helped Georgia be the #1 state to do business by offering competitive bids for electric power supply. But otherwise, it is a franchise monopoly for all of your residential and small commercial consumers. Well, there's been a lot of talk about being a monopoly, and rightfully so, but the other piece of that that is not often mentioned is that in exchange for the state-granted monopoly, the conditions that go along with that are that we have an obligation to serve, because electricity is a necessity. We have an obligation to serve every single customer in our assigned territory, regardless of location, regardless of size of customer. We have no choice, and we have to do that, whether it's, when I say we, Georgia Power, Electric Cities, or Georgia EMC. When we have that obligation to serve, it's also without discrimination to any single customer or to any class of customers, and the Public Service Commission has jurisdiction over any complaints from a single customer or a class of customers. So that obligation to serve is the condition upon which that monopoly is granted, and those two are hitched together. There's been a great deal of confusion and misrepresentation on the obligation to serve on similar legislation on rural broadband with the EMCs over in the Senate, but we won't get into that here. I will mention that relative to the Territorial Act starting in 1973, the EMC Act was established by this General Assembly in 1937. There was no such monopoly status or obligation to serve. There was just the idea that electric cooperatives would use federal loans to help provide service where for-profit and traditional utilities could not make the numbers work to reach out into the sparsely populated areas. It took almost 30 years in some cases to fully build out the electric cooperatives, and you can see that it was only until it took until 1973 before there was actually a monopoly franchise territory assigned, because the electric system had built out that robustly. So there's a parallel, Mr. Chairman and members of the committee, in this walk back through time to where we are today with rural broadband and internet. So a couple of other milestones to think about is that on the telecom side, Judge Green broke up Ma Bell, or the Bell system, back in the early 70s, deregulating telecom for all time, and in doing so, that breakup has taken away that obligation to serve, really, as it relates to internet, if you fast forward to today. Additionally, the FCC rate in Congress that was established back in the 1970s, Congress authorized the FCC to establish their rates and terms and conditions and so forth, but Congress also specifically exempted electric cooperatives and municipal utilities. This, by act of Congress, the FCC rate only applied to investor-owned utilities. There are 21 states, as Mr. Mackey mentioned, that have reverse preempted this congressional mandate on the FCC rate. But we know of no state, and we've been polling our members around the country, our colleagues, and we're in all but 2 states in the country, electric cooperatives are. We know of no state that has unilaterally imposed, as this legislation does, the FCC rate all across electric cooperatives entirely. In those states that have reverse preempted, generally speaking, it's more akin to the proposal that Mr. Lofton mentioned, and that we have great, we're encouraged by their willingness to have the PSC as a dispute resolution venue for the concerns that both parties have relative to pole attachments. The cable industry's concerns are more about rates and some terms and conditions too, I think they would say. our concerns are the same, but we just respectfully agree to disagree. We're going to ask this committee to vote against this bill. We believe it is not in the best interest of customers. We know that there has been no evidence presented that reducing the FCC rate, reducing our attachments to the FCC rate, will actually result in an expansion of broadband. We think the notion that our pole attachment rates are a barrier to the deployment of rural broadband is a red herring, because the biggest barrier to deployment of rural broadband is population density. You have this diagram here and this handout. It's about 3 pages. We presented this same document I did to another committee in this House February of last year. It's dated at the back. Here, we would take great issue in this issue being able to be simplified down to just one committee hearing today before you take action on this bill. This is a very complicated issue. I have, and I'll submit to the chairman, this is a 35-page model agreement that we reached with the cable industry 10 years ago. The second largest cable provider in the state has recently executed an extension, a 10-year extension of this very agreement that takes them out to the late 2020s, almost to 2030, just in the last 3 months. So we would argue that if this agreement is so onerous, it is confusing to us why the second largest cable provider in the state would actually agree to extend that agreement for an additional 10 years. Additionally, the ACE Act, we're very encouraged that the state has taken the initiative it has to address rural broadband and the provisions in the ACE Act that provide the framework for rural broadband. The state of Georgia, relative to the FCC, asked the implementers of the ACE Act, which is the Department of Community Affairs and the Georgia Technology Authority, to determine whether the FCC map was adequate in determining what is served and unserved in this state, and if not, make your own map. And the state has determined that the FCC map is not adequate. It in fact overstates grossly what is served and unserved in this state. And we would argue that if the state has determined that the FCC overstates what is served and unserved, and that is widely held, then why is the FCC rate for pole attachments also something that we should trust as the gold standard? We have many concerns, and I only asked yesterday afternoon for some pictures of violations. Representative Henson, back in the consideration of House Bill 23, mentioned stub poles, the concern that she has with stub poles scattered around her district, and we've heard that from a number of people. Well, I asked for pictures of these, which are ultimately, they are safety violations. They're not just a nuisance visually, aesthetically, but they're also a safety and a liability concern. The pole owner, which is the electric utility in most cases, bears the brunt of that liability. We think there's some real opportunity in perhaps something akin to the call before you dig law that the PSC currently governs for all utilities that could help provide a dispute resolution for consumers and the public and others to address many of these public safety and other hazards that are out there. I've got a number of pictures here. I will share these with the committee of these examples of safety hazards.
All right, well, thank you, Mr. Berner. As you might imagine, you do have a couple of questions if we
Yes,
could.
sir.
Representative Bennett, I believe you have a question, ma'am.
I do. Thank you, Mr. Chairman, and perhaps the question was for the last presenter and I didn't get my light on. Let me just say, let me thank you for your explanation. Fairness is an interesting term to use. I do support equity and proper apportionment in the rates. My concern continues to be about reaching the underserved, and I can appreciate the EMC's commitment and obligation to serve, but I'm also concerned about the broadband and internet commitment and obligation to serve, and is there such a mandate or requirement that they may do the same?
Yes, ma'am. Thank you for that question. And it's my understanding that at the federal level, there is no capacity for any state or the federal government to require a monopoly for the provision of broadband services, which would be required to have an obligation to serve. If you have an obligation to serve without a monopoly and a funding mechanism for the provider to meet that obligation, that is literally a taking and would be litigated. Thank you, though.
Thank you. Representative Williams, I believe you have a question, sir.
Yes, thank you, Mr. Chairman. There is some concern, and I understand the finances of being able to cover this entire state, which is the interest of many of us, particularly those of us in the rural. Is there an availability of low-cost loans that allowed you to bring lights and others to bring telephones to this entire state? Can you get the low-cost loans from USDA that they got?
And thank you, Representative Williams. And you're speaking about for rural broadband specifically?
For rural broadband, because I understand because of some cost restraints, I see some gaps. And the gaps are the reason we're here.
Yes, sir. Thank you for that question. The legislation carried by Chairman Penny Houston and heard by this committee and voted out of this committee and adopted by the House without a dissenting vote, House Bill 23 provides EMCs the statutory authority required for us to be able to access USDA funding for rural broadband, or any funding for specifically for rural broadband. But the biggest move currently at the federal level with serious funds, $1.75 billion over the next 5 years, is at USDA, and electric cooperatives right now are the only potential participant in rural broadband that are ineligible to access those funds. So the House Bill 23 that y'all have already passed addresses that, but any other provider in the state currently can apply for those funds.
Thank you, sir. Representative Dukes, I believe you have a question, sir.
Actually, I have a series of questions.
Representative Dukes, you know who's going to use this building at this room at 9 o'clock?
We might have to table this because what it did, I'm looking at it, it opened up a whole new can of worms. Because what it sounds like is, to me, is it not true, that you all are charging a rate for access to your poles that perhaps is going to exceed the FCC rate as it currently exists. So now, as we move you into the underserved areas, is it not true then it is going to have an impact on your current business model, your financial model today? So what that will do, is it not true that if you charge less money now for poles, in order for you to stay at the same rate of return, well, you all are nonprofits, but in order for you to generate the same amount of revenue, what you might have to do is to go up on someone's utilities bill. Is that not true?
Yes, sir. So, may I follow up on that? So, Representative Dukes, I'm pretty sure I followed your question there. And so, yes, and as we point out very plainly in this document that we've widely shared with committees in both the House and the Senate, our rates are significantly higher, and our counterparts with the cable industry will say that EMCs And it's also important to note that the electric cities, which there are 53 electric cities in this state, so that totals up 94 utilities other than Georgia Power in this state are not required to use the FCC rate, and we all charge probably 3 times more for access to our poles than Georgia Power is mandated to collect from the cable companies by the federal government. We do not get the number that we agreed to in our model agreement does not fully recover the cost of the electric consumer for our obligations in owning that pole, which includes our right-of-way maintenance, our storm recovery when a Hurricane Michael comes through. The cable company nobody can get their service back out to their customers until we get that pole back up. When a tractor trailer pulls down a low-hanging cable wire at an intersection and causes the electricity to go out for public service and also creates a hazardous situation, those safety violations and the liability for accidents like that, which happen frequently, those are very serious problems that we do not fully recover the cost. We struck a compromise with the cable industry in this agreement, and that's why we would almost welcome the opportunity for a dispute resolution venue that had teeth, because the current agreement does not adequately address the ability to clean up these stub poles that are left out there scattered all over the state. It's a serious concern for us.
All right. Thank you, Mr. Ferner. I believe Chairman Stevens, you have a question?
I do. It's that shocks me, since House Bill 23 specifically, if you guys will remember, prohibits cross-subsidization. So to your question, that is, if House Bill 23 passes, and it passed unanimously, I think one of the first bills that did that, it will eliminate that problem and make that illegal.
Okay. Thank you, Mr. Chairman. Representative Jones, I believe you have a question, sir.
Wave off.
Wave off. Okay. Representative Saines, do you have a question? One second. Okay, please state your question if you would, okay?
Mr. Chairman, I'm aware of the cross-subsidization that we passed in the legislation. And you're right. The legislation that we already passed somewhat addressed that, and it kept you all from being able to charge a different rate. I think most of us, what we were trying to accomplish is trying to get broadband in an area that it did not exist. We were not trying to get in the middle of you all. I know I wasn't. I wasn't trying to get in the middle of you all's other squabbles. It seems like you all had kind of worked out. But it does give me this concern, because I do represent a rural area. And when it comes to me that the people in Colquitt, Georgia, and Donaldsonville, who's probably on EMCs, their utility bill goes up and you raise them, and you're going to say it's because of what the legislature has done, then that causes me some concern. I think we do need to have some fairness across the board, but I'm trying to keep me from having some problems when I get home when the session is over. Is that not true?
Yeah.
Thank you, Representative. Representative Saines, did you have a question?
Is there what the original reasoning for the FCC not to include y'all in the regulation that governs the rates that Georgia Power has? Was that a specific exemption, or were y'all just not covered?
It was a specific exemption and act of Congress. Again, this is over 40 years ago, that's congressional action. And if you think about in the early 70s, the cable industry was a fledgling industry at the time. It was the FCC rate for pole attachments mandated on investor-owned utilities because, by and large, investor-owned utilities were serving all of the urban areas where cable was being deployed. Electric cooperatives didn't even have, they were having they were in some cases almost still on a party line system for telephone, and cable wasn't even a consideration. So the electric cooperative area is not an area of robust deployment of cable anyway. Does that answer your question?
Sure. Quick follow-up. So would this state regulation put y'all under the same regulatory oversight as, in terms of poles, as Georgia Power? Okay.
This legislation would impose the FCC rate on EMC pole attachments the same as Georgia Power is currently required to use, as I understand it.
All right, thank you. Representative Henson, do you have a question? Sorry.
Thank you. I just want some clarification on all of this. You're talking about EMC poles strictly. So in my area, DeKalb County, you really aren't there. Is that correct?
Yes, ma'am. But for the most part, we have a few customers in eastern DeKalb, but not many.
But in terms of poles?
Poles also. We have some territory in DeKalb County, eastern DeKalb, but not much.
Okay. Now, my other question is, you passed around a picture and you showed half a pole, but it was the bottom half still in the ground that still had wires hooked.
Yes, ma'am.
Okay. My concern that you referenced earlier has been when an entire pole is taken down and the top half is left on the ground because of the attachees. Could you tell me if there is any process for the owner of the pole to notify the attachees to come get their wires off so that that pole that is left on the ground in our communities is taken away, can then be taken away?
Yes, ma'am, and there is a robust national system called INJUNS, INJUNS, and I'm going to let David McCullough speak to how the notification process works in relocations, Mr. Chairman, to address her question specifically.
Yeah, specifically the system, and I think Andy Mackey covered it a little bit earlier. It's called INJUNS. It's National Joint Utility Notification System. Actually began here in Georgia, but it's an internet-based system. All the utilities have certain member codes. Comcast, for instance, has them by county, so you know where to get to. But as anything happens, whether it's new pole work or anything else, this is a way to notify people. If the power company sets a new pole, they'll usually have the first step to be set the pole. And when they complete that, and you list all the people that need to transfer, and the last step being remove the pole. And so as each person completes their step, and if they participate it regularly and mind their store and move their step from pending to completed, it notifies the next person on the list all the way down the line. It's a good system when it's utilized properly.
So as a follow-up, there's no time frame?
Yes, ma'am. There are usually, they set 30-day steps is a standard, industry standard, no set rule on that, you know, between individual steps. The agreement that we have with both AT&T and the cable companies, there's also penalties that the EMCs can apply to these people if they get so far down the road, you know, like $5 a month penalties, which is not really significant, but it was part of the negotiation to provide some incentive to get that work done.
So as a follow-up, does that penalty also apply to Georgia Power and AT&T?
That's not in.
So in my area, which is not rural, it's urban, I need something different than what you're talking about, and I need different legislation to address getting the notification from Georgia Power and AT&T to the attachees with the time frame to get their things removed. Is that correct?
Yes, ma'am. You would need to ask Georgia Power representatives and AT&T and others about their specific agreements. Most are tied to the FCC formula, as I understand it, but some are independent agreements that pre-existed the FCC action. But I will mention this, that even with the engine system and the notification requirements that are set forth in our 30-something page contract between the parties, as David mentioned, the $5 a month penalty after 6 months of inaction really is not enough incentive to get them to move it. That's why they're left. And we have several examples of engines tags requesting relocations that have been there for over 9 years.
So what would allow you to be able to take the attachees' wires off those poles that are down? What do we need to do?
I'm sorry, I don't...
Okay,
gentlemen,
if
if I may, in the issue of time, we've got another speaker that we would like to come. I'd encourage you guys maybe to spend some time together if you could offline. Gentlemen, I would like to thank you for coming this morning and sharing your thoughts on this. Thank you very much. I'm sure it'll be a great debate, and we look forward to hearing from you.
Thank you.
Ms. Maxwell from TAG, I believe you have some thoughts you'd like to share.
Good morning, Chairman, members of the committee. My name is Heather Maxfield. I am with the Technology Association of Georgia. We represent about 35,000 members across the state, and we have 5 different chapters: Augusta, Athens, Columbus, Middle Georgia, and Savannah. I guess I want to just say, too, that I have also been the liaison for our TAG Infrastructure Society. We have 26 different societies that talk about different issues, and infrastructure being one. I've had the opportunity to listen to the different technologies from the different companies over the last few years, and they'll argue about, my technology is better than this, or this fiber versus copper, but the one thing that's remained the same is the permitting process. Most of them find it wrought with difficulties, I would say. I talked to 2 companies this morning. One of them said that they're pulling out of the state because it's become too costly and timely. I think they said it was about 1.5 years to do the permitting for one area. Excuse me. And the other company said that basically it's just, I have to deal with 5 different jurisdictions on one different pole. So we are very pleased with HB 244. We thank the chairman for bringing this to the committee. As the chairman knows, we are working on a logistics task force in Savannah, and essentially what we try to do across the state is build a technology ecosystem, right? And in order to do that, we need to have the broadband throughout the state. What we feel HB 244 does is it allows for there to be parity with the EMCs, which we, welcome them into the market. However, if you are going to have a monopoly, that could discourage more broadband throughout the state, correct? So we would highly support HB 244 and ask for your favorable vote on this matter today.
Thank you, Ms. Maxwell. We appreciate your comments today. Thank you for coming. I will point out that this is a hearing only, that we will be back next week to vote on this bill. I'd like to thank the members for participating. Mr. Chairman, I believe you have a question first before we go.
I do. If you will, members, before you go, we've got, I've had some conversation from all sides that we might have some movement. This has been going on, ladies and gentlemen, for 2 years. We cannot pass the 2 bills that we just passed without some conversation on this measure of getting this fixed. We cannot allow a wholly owned, mitigated, non-competitive situation with a with the EMCs. We just cannot do that. So the conversation will be back. Today is day 16. We are over halfway there. Those other bills are gone. They set the groundwork, but we have to make the playing field level. We'll be back next week with the result of these conversations. Thank you.
Thank you, Mr. Chairman. This meeting has concluded. Adjourned, excuse me. This meeting is adjourned. Thank you.